The Family and Medical Leave Act, or FMLA, requires certain employers to provide certain employees with up to 12 weeks of unpaid leave per year for certain reasons. The FMLA applies to employers with 50 or more employees. Thus, if you have less than 50 employees, you are not required to comply with the provisions of the FMLA. If you have 50 or more employees, the FMLA applies to you. What employees are covered by the FMLA? In order to be eligible for FMLA leave, an employee must have worked for the employer for at least 12 months and also have worked at least 1,250 hours within the last 12 months. An employee who does not meet both of these criteria does not qualify for FMLA leave. For what reasons can an employee take FMLA leave? The FMLA was created to address the growing needs of workers to balance family, work, and other obligations. Thus, FMLA leave can be taken for the birth and care of a newborn child of an employee or placement of a child with an employee for adoption or foster care. FMLA leave may also be used for the care for an immediate family member with a serious health condition or for a serious health condition that makes the employee unable to work. Under the FMLA, an employee's job must be protected. Thus, the employee must be restored to their original or an equivalent position. In other words, the same or equivalent pay, benefits, and other employment terms once they return to work. It is important to note that an employer may require the use of accrued paid leave at the same time that an employee is taking FMLA leave. Other provisions of the FMLA include notice and information requirements from the employee. Finally, it is important to note that the FMLA includes a special extended leave entitlement to care for a member of the armed forces.